737 style, State of Texas versus Amber Renee Guyger. Mr. Hermes, are you ready to proceed?
Yes, we are.
And Mr. Rogers, are you likewise ready to proceed?
Yes, Your Honor.
Now, this morning, or rather, at some point last week, I was emailed a number of additional motions in limine. I have 2 from the state, and I believe 3 additional motions from the defense. And I assume, or I've been told, that it was the intention of both parties to file each of these motions, or all 5 of these motions, under seal. Mr. Hermes, was it your intention to file your 2 motions under seal?
Your Honor, I think I just emailed my motions. I will file them under seal. At this point here, until we know the condition of the jury, once it is actually filed with the clerks, it will be under seal.
What do you mean by until we know the condition of the jury?
I don't know if Your Honor is going to ask the question or not. But at this time, it's my recollection, unless I'm wrong, that I emailed a copy of my motion in limine, the one concerning lighting, to you and to the defense.
Yeah. Now, I didn't want to put assertions on you about the sealing. I know that Mr. Muller's 3 motions, there was a request, or at least you informed the court that your intention was to file a request that they be filed under seal.
Yes, Your Honor, and I prepared an order granting the request to file under seal.
And so, Mr. Hermes, your request concerning the lighting, are you requesting that it be filed under seal?
Yes,
not?
ma'am, I do.
Okay. And then you had an additional one concerning lighting. The second one went to an attempt at reconstructing a video and/or photography. Is that one likewise? Oh, I'm sorry. One Mr. Fine filed went to the testimony concerning sleep deprivation.
Your Honor, that one was filed under seal Friday afternoon.
Well, none of the sealing happens until I issue such an order, so I'm assuming that's your request. And if you filed it, I don't know whether or not the clerk put it on or not. Nevertheless, did you provide copies to the defense?
We did, Your Honor.
And do you have any objections to the state's 5th motion in limine, as well as their motion in limine concerning sleep deprivation and any sleep-related condition?
We do, Your Honor.
Do you have objections?
Yeah, we object on, yes, Your Honor.
To each of them?
Yes, Your Honor.
Okay. Well, let's begin with the state's 5th motion in limine. Mr. Hermes, are you ready to proceed?
Which is that going to be the one concerning lighting conditions, Your Honor?
Yes, sir.
Okay. Your Honor, do you want this in the form of a proffer, or would you prefer this in the form of testimony?
I would prefer proffer, but depending on the nature of the defense's objections, we may have to have testimony.
All right.
If I could just, this is you don't want me to get into the video with regard to the lighting that the Rangers did, correct?
That's correct.
Okay, I'll wait. I'll wait to have a hearing on that, Judge. So I'll agree to that.
And I presume we're not going to have any expert testimony concerning sleep deprivation or any sleep-related condition without a hearing, or
That's
that's Mr. Fine's motion.
Yeah, my concern with that, Your Honor, and I only spoke briefly with the defense, but my concern was any mention of it in an opening statement. And so, obviously, we don't, not knowing what their case is going to be, we wouldn't anticipate them getting into sleep deprivation until their case in chief, but we didn't want any mention of it in an opening statement. It's specifically related to, as the motion states, anything concerning negating mens rea or mental culpability.
Judge, just briefly on Mr. Muller's supplement, our defense is self-defense, and so we want to present all the facts and circumstances that apply to our client. So the fact whether she was sleep deprived or not, is just a fact that the jury may consider, and for whatever weight it's worth, and applying that to the facts and circumstances that she experienced.
Your Honor, if I may, the issue goes to Technical Penal Code 8.02. Mr. Fine's motion discusses diminished capacity. Diminished capacity, I've litigated the issue in death penalty cases. That goes to a mental illness. We're not alleging that our client's mentally ill, so this is not a diminished capacity defense or issue. So we wouldn't be bringing that up anyway. So,
Well, just from the body of the motion, I presume that, like most of you all's motions in limine, this is just another reminder for everyone to follow the rules of evidence and not to enter into areas that might require expert testimony. I think sleep or lack of sleep certainly may be relevant, and whether or not it rises to the level of sleep deprivation or any sleep-related condition, that might be an area for an expert, I don't know. But I don't think statements regarding a person having had a limited amount of sleep should necessarily be off limits unless it goes much further than that.
and Your Honor, we agree with that. Again, you know,
We're good.
Yeah.
Judge, just the factual issue and not get into further expert-related testimony until that time.
So just so we're clear, as it relates to the state's fifth motion, both parties agree that there will not be any reference or alluding to in any manner, directly or indirectly, the existence or non-existence of any attempted lighting reconstruction video or photography attempted by the Texas Rangers.
The state agrees to that.
Yes, Your Honor.
And insofar as it relates to the state's motion in limine, specifically regarding sleep deprivation or any sleep-related condition, the parties are not precluded from mentioning a lack of sleep, but anything that might need or require expert testimony in this area, you're precluded from entering into that area without the hearing.
Yes, Your Honor.
Right. Deputy Warren. So and now, let's turn to the defense's newly filed motions in limine. And let's begin first with the defendant's motion in limine regarding George Reese. I hope that's the correct pronunciation for his name. And any evidence concerning lighting. Has the state had an opportunity to review this motion?
Yes, Judge, I've had an opportunity to review the motion. It's my understanding that it's very similar to the state's fifth motion in limine. And I think to the extent that it puts off limits anything that would be based on expert testimony subject to a hearing, we would have no objection. As far as any testimony regarding what we think the evidence would show as the lighting conditions were, whether they're going to say it was dark or we're going to say it was light, that wouldn't be based on expert testimony, the state would ask that not be off limits, of course.
Mr. Roger, you jumped up. I'm assuming you have something to say.
Just on the understanding, I mean, there's a factual dispute probably about the condition of the lighting in the apartment. So I think both sides can go into what they believe the lighting was without getting into down the road on expert testimony.
I think that's fair.
And Judge, that would just require the court to limit the motion in limine, because the final request is that the court preclude the parties from discussing any possible testimony or opinions from any other source regarding lighting.
Well, I think we can have reasonable discussion concerning someone's description that it was dark. Now, if you want to have an expert to tell us how dark, or how much light a television being on gives off, or how much light a computer gives off, if we're going to venture into those areas or into the specificity of what is dark and what is light, then of course the motion in limine will be granted insofar as the specificity of what is light or dark to the extent that you want to rely on expert testimony, if that makes sense.
Yes, Judge.
Judge, can I ask for just a look? May I ask something, just seeking absolute clarification just from my end?
Yes,
Because
sir.
I do want to cover this briefly in the opening statement. So the testimony of lay witnesses or the observations of lay witnesses, having done no expert analysis, but their observations of the light in the room, given certain conditions, that is fair game.
Yes.
That's what I thought Your Honor ruled, but I wanted to make sure that was crystal clear.
Do you have any objections to that, Mr. Muller or Mr. Rogers?
I guess I'm just unclear because the only people that were there at the time was my client and Mr. Jean. So I don't know how, I mean, I guess if, well,
I don't know how I,
okay.
there's so much I don't know. But I don't know. We'll see how the facts shake out. A second motion in limine filed by the defense related to the state's use of the term victim or victims. I'm certain that, generally speaking, the state is well aware to use the phrase complainant or complaining witness. I don't know that every person, lay person that might take the stand may not use the phrase victim. Someone might. I'm just astounded that all of these motions in limine that we have filed are just reminders to everyone to follow the law. So insofar as the state is concerned, please, as best as possible, limit your references to Mr. John as the complainant or the complaining witness. Okay. So in essence, I guess that is granted. And last, but certainly not least, is the defense motion in regard to the state's use of data extracted from the defendant's cell phone or received from the defendant's cell phone. Is there a proper part of the state?
Yes, Judge. I know the court previously said that you would prefer to do a proffer as opposed to live testimony. Proffer is going to have to be sort of divided up because the motion in limine is sort of divided up into several different objections. By my count, I see a relevance objection, which kind of reads as an authentication objection, a 403 objection, a confrontation clause objection, a 3836 objection, and a due process clause objection. Michael, am I reading that right?
Except the part about the relevant objection is not an authentication question. We're not disputing that, like for instance, Mr. Slows, who is an expert, extracted certain data from Ms. Guyger's phone. We're arguing that certain things that the state wants to get into with regards to that data is not relevant to the case in chief. So it is a standard 401 objection that I'm making as to those documents that are from the cell phone, Your Honor.
Okay. One moment, Judge.
Yes, please.
What I've provided to the court are the cases of Butler v. State, 459 Southwest 3rd, 595. Tienda v. State, that's Tienda, 358 Southwest 3rd, 633. Rand v. State, that's an unreported 14th Court of Appeals opinion, The Westlaw citation is going to be 2017 Westlaw 4273177. Price v. State, an unpublished Dallas case, Westlaw citation 2019 1186664. Jackson v. State, another Dallas case, Westlaw citation 2015 3797806. Walter v. State, which is a not yet published Eastland opinion, Westlaw citation 2019 Westlaw 4135461. Snow v. State, an unpublished Fort Worth opinion, 2019 237734. Stevenson v. State, unpublished Amarillo opinion, 2011 4027721. And U.S. v. Tolliver, a 7th Circuit federal opinion, citation 454 F. 3rd 660. Starting with the relevance of the evidence, Judge, it's my understanding that the evidence that's objected to in this motion in limine is the content of text messages between the defendant and her partner, which shows several factual issues. One of the issues is that the text suggests that the defendant and her partner were engaged in a sexual relationship, and that they were discussing that relationship on the night of this shooting. The text messages also indicate that the defendant was texting that partner while she was on the phone with 911.
Okay, hold a second. Wait a minute, hold on. Why do you have a laptop in here?
I'm so sorry, I'm the investigator.
No, I asked you, why do you have a laptop in here? Are you an attorney?
No, ma'am.
Please give that laptop to the bailiff, and you put it wherever you wish to put it. I've asked, I don't know how plainer I can make it.
So sorry.
And why are the,
I don't know what's happening. It just,
I know, please bring it to me, sir. Just please bring it to me.
so sorry, Judge.
You've been here more than anybody. You've been here almost every time we've had court. I don't even know how this could happen.
I
I don't need any apologies. Just let me have it. Just let me have it. And why are the people locked out? This is the people's courtroom. Let the people come inside. Now I'm going to ask one more time. Does anybody have any electronic devices? No cell phones, no laptops, no tablets. That row is to be left vacant. Ladies and gentlemen, I really do appreciate your interest, but our goal and objective here is a fair and impartial trial. I don't need any additional distractions. I don't need any commentary from the gallery concerning anything that you may hear from this witness stand or from these attorneys. I want these 12 people that are going to sit in this box to receive the evidence from the witness stand. Not from any nods, not from any gestures, not from any running commentary from the gallery. This courtroom is open to the public. We most certainly will try and save seats for the immediate families of both parties, but I can't save every seat, nor do I have any intention. But we're not going to have this trial disrupted repeatedly by cell phones, laptops, and computers going off. If your cell phone or laptop goes off or I see it, I am going to confiscate it and keep it until this trial is concluded, one way or another. Because I've posted the court's rules clearly, and they're not new just for this trial. I have long outlawed cell phones, laptops, and tablets. And if I see that you're being disruptive, or you're overly exaggerated, or you're nodding or giving indications to witnesses on the witness stand, I'm going to ask you to leave. Because as I said, the decisions that will be made by these 12 persons based on the evidence that they received and the law that I provided, and that alone. Okay. Now, Mr. Gladden, are you ready to proceed with your motion in limine, with your response to the defense motion in limine concerning the data extracted from the defendant's cell phone?
Yes, Judge, I am ready. Judge, I believe before we recessed momentarily that I had gotten into some of the details of the defendant's text messages on the night of the shooting. The remainder of the proffer is that the cell phone extraction contains text messages, it contains phone calls, it contains web search history. The copy of the extraction that the state intends to admit into evidence has been redacted to omit evidence or information that has already been limited by the motions in limine. So any references to any statements that the defendant may have made to investigators in this case will be redacted. Any privileged communications between the defendant and her counsel as evidenced by the to and from names in the text messages has been redacted to avoid any violations in that regard. We have an unredacted version for the court for record purposes, but the version that the state intends to offer into evidence before the jury has removed all of that privileged information and information that has been excluded by the court's order in limine. The remaining content and context of the text messages and phone calls is relevant in this case for really two reasons, and they both go to what is required for evidence to be relevant. The case law given to the court says that first, to be relevant, the evidence has to be authentic. And then second, under the rules of evidence, to be relevant, evidence must make a fact more or less probable than it would be without the evidence, and that fact must be of consequence in determining the action. So the first question is authentication, and here I'm not talking about the authenticity of the cell phone extraction, but authentication in the sense of these are text messages that the defendant composed. And these are text messages that were sent to the defendant, and these are phone calls that the defendant made and web searches that the defendant made. And in that sense, authentication at this point is a threshold question, and what this court has to ask is whether the jury could find that the evidence is what we claim it to be. And what the Court of Criminal Appeals has said in Butler and Tienda, which I provided to the court, is that that evidence can be shown by circumstantial evidence, the nature of the conversation, the identity of the cell phone subscriber, evidence showing who was using the cell phone, information in the messages showing that it could have only come from the defendant. And so the state's proffer for that part of authentication is that the messages themselves and the data surrounding the messages will show that the defendant sent these messages and made these phone calls. Just very briefly, the text messages on September 6th start while the defendant is at DPD headquarters. And the state will have both GPS evidence and testimony from other witnesses to confirm that the defendant was at DPD headquarters. And so the text messages include statements like, "We're coming with all of them," "Why y'all have to go back?" "SWAT was leaving and needed perimeter officers." This is information regarding the defendant's assignment on September 6th, and it's corroborated by the other evidence showing where the defendant was. Then there's text messages between the defendant and her partner about her partner going to a scout meeting. That's information only the defendant and her partner could know. There's text messages then showing that the defendant got to the jail at about 8:00 p.m. on September 6th. And again, that's where the defendant was, and there will be other evidence showing that the defendant arrived at the jail, including the GPS evidence from her car. Verizon records and the defendant's partner will also confirm that later the defendant left the Dallas Police Department Southeast station and made a telephone call with her partner just after 9:30 p.m. And there's a text message at 9:33 p.m. to the partner where the defendant says, "I'm barely walking out." And there's evidence that she plugged in her body-worn camera for that night. Again, this is just corroborating evidence that the defendant is communicating what she's doing as shown by other evidence. And then the cell phone records show that there's a 16-minute and 44-second phone call between the defendant and her partner starting at 9:38 p.m. on the 6th. Then the text messages go on to show the context surrounding the shooting. Of course, there's the 911 call, which the state will be admitting into evidence, where you can hear the defendant's voice admitting that she shot Mr. John. And the records show that call, and there is body cam video of a first responding officer that actually captures the defendant saying what we hear on the 911 call at the very end. So the evidence overlaps in showing that the defendant is the person using her phone. During the 911 call, as shown by the timestamps, the extraction shows the defendant is also sending text messages while she's on the phone with 911 to her partner. Then later she continues texting her partner using the Dallas Police Department code for a shooting, which only a police officer such as the defendant at the time would know, and telling her partner to please call her. Then later, after the shooting, there's a text where the defendant says, "They have me in a car." And this will be confirmed by dash cam video showing the defendant in a police car. The state will also have evidence from the Texas Ranger investigating this case that the investigating ranger seized the defendant's cell phone from the defendant and that she gave him the passcode to unlock the phone. The text messages go on in the days following the shooting, where she texts to her partner that there's talk of arresting her, which only she would know. She describes being scared. She describes being at the Dallas Police Association. Her partner says that he's on his way when he learns that, and he will confirm that when he testifies. And there are additional conversations between the defendant and other police officers where the defendant is asking them to go to her apartment to retrieve her belongings. She includes she verifies her apartment number at the apartment complex. Additionally, there will be body-worn camera of responding officers in the immediate aftermath of the shooting, in which the defendant can be seen texting on her phone while some of these text messages are being sent. 2 days after the shooting, the defendant begins sending text messages, including to her partner, saying that she now has a new phone number and changing it. So she's confirming both her old number and her new number in those messages. And then finally, there is a text that the defendant sends to her partner 2 days after the shooting with a photo of her and the partner from an earlier time in their squad car. And she says, "I sent this so you'll know it was me." And Judge, what this proffer is meant to do is to show there is mountains of circumstantial evidence that this court can consider to find that the jury could conclude that the text messages on the phone were written by the defendant or sent to the defendant, and that the phone calls were made by the defendant or to the defendant, and that the web searches were made by the defendant. There is plenty of evidence to satisfy the Butler and Tienda standard for authentication under 901 to that respect, and that is the first step of the relevance analysis, because obviously if the defendant doesn't send all of these messages, then how can they go to what I'm about to say, which is her state of mind during the shooting, both before, during, and after the shooting. The relevant facts in this case are the defendant's state of mind coming to the shooting, her state of mind when she shot Mr. John, and her state of mind after shooting Mr. John. The reason why all three are relevant is because her state of mind at the time of the shooting goes directly to her intent, which is an element of the offense. But the state expects the evidence to show, just from the 911 call, that the defendant will say, "I shot a man." So the evidence will show that the defendant intentionally killed an individual. So the elements of the offense are met there. What this case is going to be about, as you heard from Mr. Rogers earlier, is the question of justification. And justification goes to whether a defendant had a reasonable belief that her use of deadly force was immediately necessary. And the reasonableness of that belief is based on an ordinary and prudent person acting in the same circumstances as the defendant. So what we have to establish is the same circumstances the defendant was in and how an ordinary and prudent person would have behaved. So what the contents of the cell phone extraction show, first of all, is what the defendant was actually doing during the course of the day. This goes to just how much work she had done. It gets into the question of her fatigue, not talking in this case about the expert issue we discussed earlier, but simply whether or not she was tired, how much work she had done, who she had been talking to, what she had been doing during the day. Additionally, the content of the messages show that the defendant at least had enough attention going to her apartment that she was able to safely drive. She was able to get through a narrow parking garage. She was able to drive her vehicle to her apartment without getting lost while talking on a phone. The messages are going to show that, or the extraction is going to show that the defendant was on her phone with her partner while she was driving back to her parking garage. And so that's going to show the lack of fatigue that she actually exhibited. She was able to get home safely. But then the content of the text messages is going to show that at some point her mindset changed. And that mindset changed in a way that the defendant began to stop paying attention to what was around her in an unreasonable manner. And to show that it was an unreasonable manner, the state proffers that there has to be more than simply showing she had been sending text messages back and forth. Sending a text message doesn't divert your attention. But thinking about the content of those messages and thinking about the content of the phone call can divert your attention. And then it's a question of whether that makes her diversion of attention reasonable or unreasonable. What do I mean by diversion of attention? That she failed to notice all of the clues as to where she was at. And part of the defensive theory of justification is going to be for her to believe whether deadly force was immediately necessary is, was she reasonable in knowing where she was at? Now that's not going to be in the jury charge, but that's certainly a fact that we are all going to be arguing in this trial, is what was the reasonableness of every decision that she made leading up to the shooting. And then of course, during the shooting, or during the 911 call, we have the additional text information to her partner. And that text is going to continue to show that. Do you want me to get into the content of that text? In the text to her partner, she says, "I fucked up." And so that's going to go directly to her consciousness of guilt, which a person's statements and actions before and after a shooting is relevant evidence to their culpable mental state and their consciousness of guilt. So Judge, that is the statement. the phone conversation I mentioned earlier that the defendant was on while driving home, the timing, there were an additional relevant aspect of the cell phone extraction for that is the timing. That phone call ended just over 3 minutes before the state believes Mr. John was shot. And so the way in which the substance of that conversation, as can be inferred from the text messages and the testimony from the defendant's partner and other officers, the substance of that message goes directly to the defendant's state of mind at the time she's walking to Mr. Jones' apartment, the time she goes in and shoots him. So that is in a nutshell the state's argument for the relevance of this information, Judge. Responding to that first part of the motion in limine.
Does you wish to reply, or will you continue with your further objections? Mr. Muller, did you wish to?
I was going to wait to see Mr. Gladden proffers it under all the theories that he wants to propound to the court, then I'll respond.
Okay. And so, Judge, the defense second objection following the relevance objection is their 403 objection. And this court is well aware, I know, of Rule 403, that relevant evidence can be excluded if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, or needlessly presenting cumulative evidence. Case law is clear that Rule 403, despite its use of the word exclude, is a rule that favors admissibility. And that's Davis v. State, 329 Southwest 3rd, 806, Hammer v. State, 296 Southwest 3rd at 568 to 69. I didn't provide the court copies of those cases. They're not directly on point factually, it's just for the record to show the statement of law that Rule 403 embodies a presumption that relevant evidence is going to be more probative than it is prejudicial. And the burden is on the defense to show a clear disparity between any prejudicial effect and any probative value. All the evidence that we offer is going to be prejudicial to the defendant, that's why we offer it. The question is whether that prejudice substantially outweighs the probative value. Well, the probative value here is the defendant's mental state and the reasonableness of any belief that she claims to have during the shooting. That's incredibly relevant because one is an element of the offense and one is the essential disputed element of the issue of justification in this case. Now, the defense presents our theory of prejudicial effect as we just want to cast the defendant in a bad light and say that a person who would send these types of messages, have these conversations, have these types of relationships is a bad person, and of course she's going to shoot somebody. That's not our argument at all. Our argument is the reasonableness of her mindset and her mental state at the time of the shooting. That's the relevance of the evidence, not to cast her in a bad light. The next objection in the motion eliminated by my count is the Confrontation Clause objection. I did provide the court some case law in that stack I gave the court. It's the final cases. That's Walter v. State, Snow v. State, and I believe Stevenson v. State, and then U.S. v. Tolliver. And the basic substance of those cases is that the Confrontation Clause applies to hearsay and it applies to testimonial. It applies to hearsay that is a testimonial statement. And these cases point out that text messages are informal statements that are not made in anticipation of litigation, and there is just no way to find that a text message made between two private individuals in an informal setting can be testimonial. And then, of course, any statement made by the defendant in the text messages is a statement by a party opponent and is not hearsay. So the Confrontation Clause doubly does not apply to her statements. Any additional statements by other people in the text messages are not being offered for the truth of what they assert, but rather to put the statements of the defendant in context. So those statements are not hearsay either, and they're certainly not testimonial. So in the same way, the Confrontation Clause doubly does not apply to any of the statements in the cell phone extraction. The defense next objection is under Article 3836, that the evidence is not admissible under 3836. Well, I read that argument, I read it as arguing two things. One, that 3836 applies to testimony as opposed to documentary evidence. And then second, that in absence of any evidence that there was a prior relationship between the defendant and Mr. Jean, 3836 doesn't apply. I'll start with that one. 3836 does include an admissibility provision for evidence concerning a prior relationship between the defendant and the victim, but that's not the sole basis for admissibility under 3836. We're not alleging any prior relationship between the defendant and Mr. Jean, so I don't think that objection really applies in this case. And the state was planning to offer testimony about this cell phone dump, but the defense stipulated to the fact of the cell phone dump. So that stipulation is that the testimony would have been offered. So if the defense is trying to limit this to say it can't come in because there's no testimony about it, well, the testimony would have been there, but the defense has already agreed not to have that testimony. With those 2 points aside, 3836 allows testimony regarding all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense. As I mentioned in our discussion of relevance under Rule 401, these messages, these calls, the web history, all of it goes to the defendant's condition of mind at the time of the offense. How tired she was, how not tired she was, what she was actually thinking about, what she was doing, how capable she was to get home safely, but then suddenly she misses all of these clues about where she's at. That goes to her condition of mind at the time of the shooting. And so the state argues that it's admissible under 3836 as well as under 401 and 402. And then finally, the last argument is due process. The defense cites two cases, neither of which are applicable here. Payne v. Tennessee was a death penalty case talking about whether there was prejudice from having a victim character testimony during the punishment phase, and they said there was no due process violation in that case. And then Rankin v. State says that character conformity evidence, that is only character conformity evidence, is not admissible. We're not admitting this for purposes of character conformity. Again, we're not saying the defendant shot Mr. John because she's a bad person because of what relationship she was involved in. We're saying the defendant intentionally shot Bob John and she wasn't justified, and this evidence proves why she wasn't justified. So there's no due process violation, there's no 3836 violation. In fact, we conform with 3836. There's no confrontation clause violation. The evidence is relevant under 401 and 402 and is not substantially outweighed by any prejudicial effect under 403.
Let me just say, the court is aware somewhat about the substance of the text messages, and I'm aware of the phone call. What I was not aware of, the web search history. And were you aware of the web search history, Mr. Moe?
We were, Your Honor, and we object to any of that as being relevant. We objected under 403.
Is this a web search on September 6th?
No, Judge. The particular web search that Mr. Mitchell has just told me about is after September. It's one of the days after September 6th. The defendant did a search for how to change her phone number, which goes to then confirming that she did change her phone number, which is one of the texts that confirms her identity as the person using the phone.
So that's back to your authentication.
Yes, Judge.
Okay. Does that conclude your objection?
Yes, Judge.
Thank you. Mr. Moe?
And I'll just start the last argument that Mr. Gladden made. Article 38.36, the Texas Code of Criminal Procedure, Your Honor, the only relevant, potentially relevant part of that article is subpart A. Subpart B would not apply because subpart B goes to, the evidence concerning the defendant and the complainant, the deceased, if there was a family violence that occurred. Subpart A, Your Honor, reads, I'm reading it for a specific reason, in all prosecutions for murder, the state or the defendant shall be permitted to offer testimony as to all relevant facts and circumstances surrounding the killing and the previous relationship existing between the accused and the deceased. That's the first part of subpart A. Together with all relevant facts and circumstances going to show the condition of the mind of the accused at the time of the offense. I read the two words together where it's being conjunctive with the first part, not disjunctive. It's not an or, it's together with, meaning and. So I believe 36A applies only where the parties want to get into evidence concerning the prior relationship of the accused and the deceased. The state just stated in a judicial statement that there was no prior relationship, and we agree. So we don't think 3836 applies at all in this case. During a prior argument, Your Honor, the state had argued that the theory is that the text messages show that Mrs. Guyger was distracted because she was either thinking something good was going to happen that night or something bad was going to happen. Our argument is, Your Honor, that's rank speculation, as I pointed out in my motion, to try to prove up someone's state of mind, what someone was thinking through text messages, can't be allowed. Because not even an expert who testifies as to circumstantial evidence can testify as to, a person, what's going through a person's mind. So we don't think 3836A applies at all in this case. Going back, Your Honor, Mr. Gladden mentioned something about, Miss Guyger being tired and, whether she really was that tired because she was able to drive home. It's never in the defense's contention, Your Honor, that Miss Guyger was in a coma when she was driving. That therefore she didn't know, she was out of her mind, didn't know where she was. It's just that she was simply fatigued and distracted, which caused her to drive to the wrong floor of the parking garage to begin with. So,
But you stated fatigued and distracted.
well, yeah, for
And I
fatigue.
think his argument for distraction relates to the text messages and or phone call.
Well, the problem is, to say that text messages exist and they were distracted is one thing. The state wants to get into the detailed content of those text messages, and some of those contents do go into things that we believe would be so prejudicial that the probative value is outweighed by the prejudicial effect in the 403. Again, concerning her prior relationship with Martin Rivera, we think that's very prejudicial. We think that is the state trying to, whether they intend to or not, trying to cast Ms. Guyger in a bad light, saying that because she did that, then she couldn't have been reasonable in her actions. So again, it's one thing, and let me be clear, Your Honor, the state originally, as was communicated to me by co-counsel, talked about doing a full cell phone dump. We definitely object to any sort of dump which allows the jury to look at all the data that was extracted leading up to September 6, 2018, on September 6, 2018, and then after September 6, 2018, until the end of the extraction. Now, Mr. Gladden, discusses Tienda versus State. I'm very well aware of that case and all the other cases he mentions. Tienda is a case out of Dallas County through the Fifth Court of Appeals. If the state wants to authenticate a communication through a witness, then the state is entitled to attempt to do that. That's what Tienda says is allowed. But here it appears that the state's trying to dump the cell phone extraction on the court and allow the jury to view the cell phone extraction based on the authentication procedures that are laid out in Tienda. And we object to that because we don't believe that's the proper way of authenticating. The only thing we've stipulated to, Your Honor, is that there was a cell phone extraction performed in this case. We're not stipulating to any contents of that extraction. Let me just be clear on that. So if, let's say, there's a text message on a certain day, or let's say a web search on a certain day, per Tienda, like someone like Mr. Sloas can only testify that that occurred on that cell phone. He can't put that into context. Context is what's important here, Your Honor. And I'll close, on my 401 argument. Context is important. Context would be made through witnesses, live witnesses, not through a series of text messages with the argument, well, if you look at these text messages, you can probably figure out really what was going on here. And that's what we really object to, Your Honor. Obviously, again, if let's say there's a text message between Ms. Guyger and Mr. Rivera, and the state puts Mr. Rivera on the stand, Mr. Rivera can testify, yes, I received that text message, or I sent that text message. Okay. That's what Tienda says. That's part of authentication. Whether it's relevant goes to whether it's relevant to the facts of the case with regards to the essential elements of the offense of murder, or any lesser included. We're objecting and saying that it wouldn't be relevant unless the proper context came up when there was someone on the stand testifying as to that context. And that's my objection, Your Honor.
Yes, Mr. Black.
May I respond to that, Judge?
Yes, sir.
Judge, in Butler v. State, which is the 2015 Court of Criminal Appeals case I gave to the court, and defense counsel has a copy too, on page 6 of the PDF, it's the first full paragraph on that page 6. It's on page 602 of the Southwest Reporter opinion. The court says, authenticating evidence may be direct or circumstantial, and that the state may bridge any logical gap and permit a proper inference that the purported author sent the message. That evidence might include the message's appearance, content, substance, internal patterns, or other distinctive characteristics. And so I would just disagree with Mr. Mola that the court and the jury are allowed to consider the substance of the messages themselves in determining whether they are what we purport them to be, which is messages from the defendant. I just want to add 2 additional responses because I neglected to make this argument the first time. One, the evidence, in addition to being relevant under 401 and 3836, is also relevant under 404B, and properly relevant under 404B as evidence tending to show a lack of accident or mistake, as well as the defendant's intent and state of mind. So these are permissible non-character purposes under 404B that the evidence is admissible for. And then finally, Judge, Mr. Mola says that this evidence to prove the defendant's state of mind would be rank speculation. I would agree with Mr. Mola. We can't put an expert on the stand and say, in my expert opinion, the defendant's state of mind was such and such based on this evidence. But this evidence is circumstantial evidence of the defendant's state of mind for the jury to consider, and the jury's fact finder can make rational inferences from the circumstantial evidence, and that includes the substance of what the defendant wrote.
May I briefly respond to that argument? Your Honor, Butler, I want to make sure I'm thinking of the same Butler case. Butler was an aggravated kidnapping case where the state, using Tienda, it's not a new case law or new theory that the Court of Criminal Appeals came up in 2015. Aggravated kidnapping case where the state put the complainant, Ms. Salas, on the stand to testify by the aggravated kidnapping. Through Ms. Salas, the state admitted electronic communication between her and the defendant. So again, context. The context was established by putting the person on the stand who actually received the text message, was involved in the communications, if I'm remembering the case correctly, and therefore those messages were deemed admissible because they were put in context, not simply because there was a data dump and the state said, well, although we don't have the complainant here and the defendant is not testifying, take a look at these text messages.
I'm just glancing at Butler, and I'm not quite sure that's what the court had. If there's no further argument, I'm going to take a brief recess, and I'll let you know my ruling concerning the text messages, phone calls, and web search history.
Judge, can I make one point on that, Judge, just briefly? We're not at this point offering the entire extraction, okay? I just want to make sure. Okay,
It is my understanding that the nature of this issue relates to the text messages that were sent on September 6, 2018, and for a few days after September 6, 2018. Is that correct?
Yes.
Yes,
Yes.
Mr. Schiff.
Judge, then, there are many texts, if they're offering, I thought it was just going to be 9/6, but there's all kinds of texts in the following days. that
Yeah,
have-
they mentioned a number that they have excluded privileged. It's my understanding that the texts that you all are in dispute about are those that concern allegedly went from Ms. Guyger to Mr. Rivera and from Mr. Rivera back to Ms. Guyger.
But now, if they're including the 7th, 8th, and 9th, there's texts between Ms. Guyger and his sister about a news story about Ms. Guyger's brother showing a white power sign she has known nothing about. That's in there in detail.
I don't know if that would have any relevance to this. I think
There's, yeah, and there's people's opinions about the media, Ms. Guyger's opinions about a story, people saying, hang in there, none of that's relevant, Judge, but there's hundreds of them is what they're offering, and they're highly prejudicial to be taken completely out of context.
well, maybe I misunderstood the nature of the discussion that you all had with me on Monday of last week. But I thought, in essence, this centered around the text between Ms. Guyger and her partner, Mr. Rivera.
I thought they were just going to offer for the 6th of September, not the,
No, they stated clearly that it was the 6th of September of 2018 and for some days afterwards.
Your Honor,
Am I wrong in that?
I think I can clear this up.
Please do. You all may be seated.
Your Honor, for purposes of testimony concerning the event and everything that Mr. Gladden just spoke to concerning the reasonableness of Ms. Guyger's decisions, her state of mind immediately before, during, and immediately after the commission of the offense. It is the text messages that occur around 5 p.m. until, let's say, 10:30 p.m. on September the 6th, 2018, that are directly and concretely relevant to that particular area of the state's case. The only relevance, Your Honor, that the text messages have beyond that, substantially, are going to be the authentication issues that have been raised. We didn't get those until Friday, okay? But when it comes to authenticating the context, as Mr. Mola has said, basically, they are putting us to proof, circumstantially, that that phone was in the possession of Amber Guyger. And so therefore, it is potentially relevant if the court or the jury has issues concerning the authenticity of who sent it, her conversations with her sister. Her sister's name is Alana Guyger. Her sister does have a person who did make signs that were arguably race-related. I don't see that as having any relevance whatsoever unless they put us to proof that that was her and her on her phone. The fact that she got that message from her sister, that is the relevant portion just as to authentication. But I will tell you, Your Honor, I mean this in good faith. The only interest I have for this part of the case is the text message exchange that occurred on September the 6th between her and Martin Rivera. That is the evidence that I think is absolutely probative to her state of mind, her mens rea for the commission of the offense, and her claim of reasonableness under the justification.
So are you all abandoning your stipulation that this was in fact her phone?
No, Judge, we are clear. The extraction was done on her phone, and that we're not abandoning that, Judge. I mean, we've agreed that with the state. I told them Selbright, the chain of custody of her phone and the fact that Selbright performed the extraction of her phone is not contested. And that our theory is not that those text messages were not to her phone or from her. It's I think Mr. Moe is just saying there are all these issues with that are there, but to drill into it, it's purely, you know, the legal objections to the substance of the text messages and the objections that Mr. Mola made.
And to be clear on my end, Your Honor, I was under the impression that we were just talking about the communications between Ms. Guyger and Mr. Rivera. Now, the proffer has all these other messages. We object to those as not even being remotely relevant to the case and highly prejudicial.
Did you not hear? He said, if we go to the issue of whether or not this is in fact Ms. Guyger's phone, then the state intends to use all of the extraction to prove that, yes, indeed, it was Ms. Guyger's phone. And I heard Mr. Rogers to say, you're not alleging this is not her phone. These are not her text messages, so that they don't have to go to the extremes of authenticating the ownership of the phone and who may or may not have sent the text message.
Right, I just want to drill in, you, Judge, and us, all the parties on what we're really, if that's the extent of Mr. Hermas's goal is to get those text messages on 9/6 from those time periods. All those objections regarding relevance and the state of mind, all those apply, but we are not saying that it was not her phone and those text messages, couldn't be proven that it was her. We are not contesting that.
Well, then, Your Honor, I stated my intention and that I'm going to limit it to September the 6th unless there's some reason not to, and I'll consider that to be an obligation on me in limine, that if I go beyond the 6th, I'll approach the bench.
And you are speaking specifically as it relates to your opening arguments today.
Yes, ma'am. I mean, obviously, first I have to get the court's ruling, obviously, but if the court's ruling is that the text messages and the phone calls that occurred on September the 6th are relevant under 3836, under 404B, then yes, I will include those in my opening statement, and I will limit the testimony and the evidence to that unless something develops that makes, that opens the door to a more expansive view upon, and if so, I will approach the bench.
And I don't want to be so presumptuous, but I am presuming that you do not intend to go into the specificity of the text messages, just that these text messages were going back and forth.
No, ma'am, I was going to go into the specific text messages between Martin Rivera and Ms. Guyger beginning at about 5:55 p.m. It is
So in essence, do you intend to quote from these text messages?
Yes, ma'am. My intention is to offer those records for the 6th into evidence, and then to quote with the exact time in which they were made, and the exact conversation that goes on between Ms. Guyger and Mr. Rivera.
And do you intend to provide any information concerning the nature of this relationship and the status of these parties?
Yeah, Mr. Rivera is going to testify. Now, I'm going to be very frank with you, Your Honor. I don't plan on going in and going over this information a lot. I plan on covering it in an opening statement. I do plan, I will proffer for the court that Mr. Rivera has admitted to me that he and Ms. Guyger were in a sexual relationship, and that sexual relationship had begun earlier that year. I anticipate it's going to be his testimony that this was mere flirting or banter between them at the time. I think that's going to be up to the jury to make that decision. The reason why it is so probative for the state, though, is because it shows, if those texts are taken at face value, and Mr. Rivera will admit that there was the text exchange, that there was a plan for later that evening. At 9:30, when Ms. Guyger leaves work, she sends him a Snapchat with a text that says, "Want to touch." That is buttressed by the fact that from 5 until 9:30, they've had exceptionally graphic sexual conversation, which is highly indicative that there was a plan for later that particular evening, which addresses all of the issues that Mr. Gladden talked about earlier, that we expect are going to be raised by the evidence. So it does show that there was a plan, and that's why the phone call that happened 3 minutes and 49 seconds before he died, and actually it was probably a lot less. There was a minute of 3 minutes and 49 seconds between the conclusion of the call with Martin Rivera and when the 911 call was made. Now, I have to guess that she did not have 911 on speed dial the moment she shot Mr. John. So there was some time that elapsed between the actual shooting and the call to 911. So it is less than 3 minutes and 49 seconds between that call and with Rivera and the 911 call. And that's why in that particular 3 minutes and 49 seconds, or 3 minutes and 44 seconds, there are repeated instances that the evidence are going to show of unreasonable choices and decisions made by Ms. Guyger. These all go to show her state of mind. So yes, ma'am, to answer your question specifically, I think it is critically important that the jury know that there was a conversation, that it implicates that there was a plan, that there was a call, and that immediately after that call, Ms. Guyger rendered herself inattentive to virtually everything in that 3 minutes and 44 seconds.
Can I see the lawyer receive for just a second? Now, I am not technologically savvy, and I'm glad my babies are. If you've got on an Apple smartwatch, you're not going to be able to wear that in here. When I say no cell phones, tablets, or laptops, that extends to your wearables as well. So if you got an Apple Watch, don't wear it to this courtroom unless you want me to try to hold on to it until this trial is over. Because what we're not going to have is live texting and commentary, okay? Thank you all. Having read and reviewed and heard your arguments, the court will deny the defense counsel's motion in limine in regards to the text messages and phone calls and web searches of September the 6th, 2018, except as to the relationship status of any of the parties or any of the testifying witnesses. Am I clear?
I'm very clear.
Yes, Your Honor.
Okay. Now, I would very much like to bring the jury inside, swear them in, see if we have any problems or if anybody's had any problems in the meantime where they cannot serve. Take a very short recess, allow you all to make opening arguments after that recess, and begin testimony in this case.
The state has additional, very quick motions we need to put in front of the court.
Okay. Were these filed today?
No, Judge, it's a matter of common practice. It's going to be an oral motion, Your Honor, that the court exclude the family from the rule of evidence.
Thank you.
Yes, ma'am.
I'm assuming you do not have any objections to Mr. Don's family members being present during testimony.
Unless they're going to be testifying during the case, Your Honor, would you object to witnesses that will be testifying in the case under Rule 614?
Well, I'm certain that someone from his family will testify that he was a living human being, and you object to that person remaining in the courtroom following their testimony?
I mean, if that's the extent of their testimony and they're excused after that, and they're not going to testify about a fact that's in dispute, then
Your Honor, we do anticipate the testimony is going to be some biographical information about the complainant, the fact that he was a living, breathing human being prior to this particular event. It is common practice in this county for courts to excuse the family unless there's some finding that their presence in the courtroom after having testified is going to have some material effect on their testimony either before or after. I can tell you I've gotten to know the Jean family very well, and I am more than happy to put them up so that you can inquire as to their character. I have absolutely no reservations whatsoever that any testimony will be affected at all by their presence in this courtroom.
Do you intend to use any member of the immediate family for any other factual issue in this case, other than Mr. John's having been a living person prior to the events of that evening?
Some marginally, yes, Your Honor, with Ms. Finley, his sister. I am going to explore a couple of other matters relevant to Mr. John. In addition to the fact that she had spoke with him that day, he was looking forward to his birthday coming up, that he was obviously loved by his family. There is also one other matter that I think is going to be important when it comes to scene context. I mean, there's absolutely no reason.
What context?
Well, so, Your Honor, Mr. John smoked marijuana. I think that probably that was released when the police released evidence of the seizure at his apartment way back when it happened. We're not going to shy away from that, but I do want Ms. Finley to explain that is why he used marijuana for that particular purpose, so that there's not an effort on the part to victim shame him, or for the jury to take any kind of adverse.
How is marijuana even relevant?
Okay, I can tell you what, Judge. The inside of well, first of all, I think it's going to be brought up by the defense because of who they have designated as their expert. So I do believe that the defense fully intends on going into that to perhaps suggest that his perception wasn't that of a reasonable person. That's just a guess. Of course, they don't tell us. But I certainly expect that that's what they're doing based on how they've disclosed. But secondarily, for me, Your Honor, knowing that that's already coming, I do believe that his apartment, by all of the original responding officers, they indicated that his apartment smelled of marijuana. That is yet another thing that Ms. Guyger completely did not pick up on or failed to allow to register upon her entry into his home where she shot him. Her apartment presumably doesn't smell like marijuana. So again, it goes to all of the facts and circumstances that she rendered herself inattentive to.
So you object to Ms. Finley sitting in during testimony because she will be used as another fact witness to something. Is that correct? Mr. Rogers?
No, I'll play it by it. I don't know how far they're going to go with it, and I guess it just depends if she's testifying about facts and they want to bring her in rebuttal or something like that, and if she's in the courtroom the whole time. And that's above it, that goes beyond just the normal, hey, we love him, he's a good man, and all that stuff.
So that includes, you do not, I'm just trying to be clear as to your
Right.
objection. You object to any person who's going to provide fact testimony.
Right.
Is that correct?
Yes, sir.
And if I understand you, Mr. Hermes, you intend to use Mrs. John, the defendant's mother, to provide testimony that he was in fact a live person prior to the events of September 6, 2018.
Your Honor, I was going to use Mrs. Finley, his sister.
For both issues?
Yes, ma'am. Miss Allison John, Beau's mom, she would be a rebuttal witness only if something raises the need to call her. And she's a very likely, in the event of a guilty verdict, very likely testifying punishment. I just want to reiterate for the court, I think that the analysis is whether or not their presence in the courtroom will affect their testimony. These folks were not present, so I can't get from them, nor would I even try to get from them, substantive facts of how or what happened inside Beau's apartment that night. But for background information, there's no reason for them to lie about that. And I think that any claim that they're going to materially change their testimony about the biographical information about their son, frankly, I think that that's preposterous.
I'm not questioning the biographical information, Judge. I don't know.
I just want to know if you object to their presence in the courtroom or not. They are going to testify.
Not to Mrs. John, because I believe she just purely is a biographical witness. And once Ms. Finley testifies, then I just ask for some latitude to take it up at that time, whether or not she can stay after she testifies.
So you're reserving your objection to Ms. Finley until after you hear her testimony?
Yes, sure.
Do you understand that, Mr. Hermes?
I do understand.
I'll rule on his objection to Ms. Finley if he makes it after Ms. Finley testifies. And as it relates to the other family members, they will not be excluded from the courtroom And there's a possibility that should we get to punishment, you may use one or more of them. Is that correct?
Yes, ma'am, that's correct.
Are you clear on that, Mr. Rogers?
Yes, Your Honor.
Okay. And the other persons who are present in the courtroom and have an indication that you will be used to testify, you will not be able to be present during the testimony of any other witnesses, nor may you discuss this case with any persons other than the attorneys who are representing each party in this case. So please don't discuss the case in the presence of any other witnesses or with any other persons. Okay, that being said, can we please bring in our jury and try to swear them in and see if we have any problems with any of them serving?
Judge, we have one other issue that came up last night that we're going to bring up on, but it's regard to an interview that Judge Cruzon did with Fox 4 when we discussed this case. And
The one that you had listed in Exhibit 12 of your...
it happened last night.
No, Your Honor, I have
Oh,
the
there was
yesterday.
another interview last night.
Yes, Your Honor.
While the gag order was in effect.
I have the exhibits, Your Honor. I was going to put it into the record, bring it to the court's attention.
No, I'll find this. So let me be clear. On last night, the evening prior to the start of this trial, our elected DA did an interview about this trial.
On Fox 4 News, Your Honor, yes. And I have the video and the article from Fox 4 and the screenshot from the data disk. It was short, but it was done, and it appears to be a violation of your order dated January 2019, the restrictions regarding publicity.
Okay. You have the video? Let's see it.
Thank you, Your Honor. May I approach, Your Honor?
Yes.
All right, I'm tendering to the court, and I've already given copies of these to Mr. Levin, Defendant Exhibit 29, which is a copy of the Fox 4 website where the video exists. The very first page of Defendant's 29, Your Honor, is a screenshot showing that the video is there, and then the following pages are the actual printout from the article. Defense Exhibit 30, Your Honor, is a copy of the video that I downloaded from the website, Your Honor, and Defense Exhibit 31 is just a screenshot showing the data that's on the video, showing that simply the only relevant file is 60 megabyte video from that website. That was apparently the interview was taken either yesterday or Saturday. It's unclear, but certainly he's talking about having met the family last week, and he believes the correct charge should still be murder, and he says some other things too. So I want to bring to the court's attention, usually the relief on a gag order, it's unclear what the court's relief would be, but we bring it to the court's attention, and then we move to renew our venue motion and move for a mistrial based on the violation of the gag order. We just ask for rulings on those, Your Honor. Thank you. And I ask that those be admitted for record purposes, 29 through 31, defense exhibits.
Your Honor, I have no objection for record.
29 through 31 of the defense exhibits will be admitted for record purposes. I'm going to take a brief recess to go and watch this. In all probability, I will bring our jury panel in and question them individually as to whether or not they view or were aware of this. I'm so curious to know, did you know that this was coming?
Ma'am, I was made aware of that interview this morning by Mr. Mola. I was unaware of it until tonight.
So where's Mr. Cruzon?
I haven't had a chance to talk to Judge Cruzon this morning, Your Honor.
Curious. All right. Give me 10 minutes to watch this video. Individually, so there will not be any video of them. And I'm going to question them as to whether or not they are aware of or watched or heard any of last evening's video.
We have audio only then?
No,
No audio.
just, you said you go to the seal,
Yes.
please go to the seal.
Yes.
Because I don't want, the one question they had for me was to help maintain their anonymity. So, if you know your friend's voice, you know your friend. So no, please no.
Understood, Your Honor.
Thank you so much. Your case in chief.
Yes, Your Honor.
All right. Where your objection will be overruled during the state's case in chief. Obviously, when you begin yours, you may take down that exhibit and any others that they've left up. Now, are you all going to be ready to begin at 12:30?
Judge, I was ready to go at 8.
Yes, Your Honor.
Promises, promises. Thank you. Now, when you all, if you choose to come back at 12:30, that is absolutely fine, but we are not going to be in and out and in and out. Once you're in, you may only exit during a break. Please, no cell phones, no laptops, no tablets, no wristwatches that you can use to text, any of these Inspector Gadget things. Okay? What else?
It's fast, Judge, I promise. I want to offer, for record purposes only, Court's Exhibits 13 through 19. These are a memorialization of the state's adherence to Michael Morton Act.
No objection.
Those are admitted for record purposes, 13 through 19, is that correct?
Court's Exhibits 13 through 19, yes, Your Honor.
Okay. And let me just note for the record, the motions and limines that we heard earlier today, your request for them to be sealed, of course, will be sealed. And also let me note for the record that I intend to sequester this jury for the entire pendency of this trial. Yes, Mr. Muller.
May I get the written order, Your Honor, you asked for it on the sealing?
Yes.
Yeah, approach, Your Honor.
Yes, sir. Thank you so much.
Thank you, Mike.
Anything else?
I'd like to approach the bench, Your Honor, before you leave. If I could have just 1 minute of your time with Mr. Rogers.
Okay.
That has no bearing on anything at all. I just want-
Okay, just for clarity, 12:30, you're gonna bring them in, swear them in, arraign the defendant, opening statement.
I'm